there are two scenarios that can come up. You can be what I refer to as nominally married. You were married, you've been separated for a long time, you don't even talk to each other. If you're put in the same room, it's like a dog and a cat in a burlap bag. You're just not going to be able to communicate. In that situation, your estranged spouse's income plays no role. But let's say you're living together, and you might not even be getting along, but if you're under the same roof, your income is community property, your spouse's income is community property. And you must list that income in your bankruptcy petition if you file all by yourself without your spouse, because your spouse's income is available to pay antecedent debts. That's because a creditor who wants to collect can collect from your separate property and all of the community property, and the only thing it can't go after is your spouse's separate property if your spouse has no connection to the debt. So you must list your spouse's income in your bankruptcy petition, even if your spouse is not filing for bankruptcy protection. In fact, you have to list other things pertaining to your spouse as well. You have to list, as I said, all of your spouse's income. You have to list all of your spouse's debts. Those debts may only have your spouse's name on them, but the reason you have to list them in your bankruptcy petition is the community property is liable for those debts as well. You have to list your spouse's expenses, which is a good thing because it can be used to offset the income and maybe even get you into a Chapter 7. So you have to list your spouse's income, expenses, your income's debts, and your income's assets, except for your spouse's separate property. So yes, you have to list all of your spouse's everything except for your spouse's separate property.